This is a suggested hierarchy of legislative materials for statutory interpretation purposes. After a California judge or justice determines that there's ambiguity in a state statute, then they'll turn to consideration of extrinsic evidence in an effort to ascertain the intent of the legislature in crafting the particular statute that's at issue. So, what sort of evidence is considered by the judiciary, our judicial branch of state government? Well, for more than 125 years, California courts have examined evidence of legislative intent in construing state statutes, going back to County of Yolo versus Colgan in 1901, a California Supreme Court decision. In fact, I believe legislative materials should play a critical role in the judiciary's consideration in cases of statutory interpretation. And I also believe that there should be a hierarchy of those materials used by the judicial branch. In other words, some legislative materials should be given greater weight than others. In this way, I think there should be a hierarchy of materials to be considered after the court determines that there's ambiguity in statutory language. What is the basis for this suggested hierarchy? Well, the California Court of Appeal in the Third District issued the preeminent decision in this area, Kaufman and Broad Communities versus Performance Plastering. And they determined what is or is not cognizable legislative material for the courts in our state to consider. And I understand and appreciate the concept of wanting legislative documents to reflect the body as a whole or the collective judgment of the legislature. As set forth in this particular Third District Court of Appeal decision, California courts prefer floor and committee analyses, for example, over statements by the bill's author. But I beg to differ with the appellate court in a few respects. First, there's some internal inconsistency in the reported decision itself. For example, it distinguished between cognizable and non-cognizable legislative material based upon this threshold. Was it before the legislature as a whole for its consideration? So I pose the question, with that standard in place, how is the governor's enrolled bill report cognizable? An enrolled bill report, or EBR, is confidentially prepared by the executive branch agencies, including the Department of Finance and any relevant department or agency that has jurisdiction over the subject matter of the bill. Now, the EBR is not shared with the legislature. It's submitted directly to the governor's office after passage of the bill, and the governor is utilizing it for consideration. So the EBR is not before the legislature as a whole. Now, this and some other examples demonstrate, in my mind, that the judicial branch is not fully understanding the legislative process. Judges in this state also attribute little value to the statements made by the author of the bill because they don't reflect the legislature as a whole. Yet those legislators are the most knowledgeable about the statutory language and what is intended by their bill. In utilizing the appellate court's approach generally, we could create a proposed hierarchy for consideration of legislative history materials. My proposed ranking in terms of value from a legislative perspective is one, codified or uncodified legislative intent statements, codified or uncodified legislative findings and declarations, then letters to the Assembly or Senate Daily Journal by the bill's author, followed by the floor analyses for the Assembly and Senate, then committee analyses, then materials from a bill's sponsor, and then any other relevant material used by the legislature. Now, obviously, from my perspective in this hierarchy, the author and the sponsors in particular, as well as those who actively and directly participated in the bill's travels through the legislative process, I believe are in the best position to state what the intent or purpose of an enacted statute is. Why? Because these are the folks who drafted and negotiated the language and worked on it most intimately. They are in the best position to explain the goal, the purpose, the intent, why specific language was chosen or not chosen. The legislature as a whole, of course, votes on the bill, but they do so based upon concept and the policy position. In other words, they're voting for or against a policy such as, do we want to expand the earned income tax credit to add additional beneficiaries? They're not voting on the language used. They're not voting on why the statutory language uses the term person instead of taxpayer in the Rev and Tax Code. They're not voting on potential ambiguity created by the language, either intentionally or unintentionally. They're simply voting aye or no to support expansion of the EITC or to prevent its proposed expansion. Now, I recognize that this argument will undoubtedly play into the hands of textualists, for example, and why they don't want to rely on legislative history due to its perceived lack of reliability. However, I think these folks are mistaken in two regards. First, legislative history documents are in fact reliable, albeit not in every instance, but the judiciary has to rely on the correct documents. And that is the basis for the suggested hierarchy of legislative history materials. Second, while I believe in using the text first, as do California courts, primarily because legislators do in fact draft with a purpose and try to use consistent and unambiguous and unnecessary words. So, of course, the written words of a statute should be the defining words. However, the reality is that with any seasoned legislative drafter who will readily admit that there isn't a perfect statute out there. No statute can be entirely free of ambiguity, and a statute cannot encompass every possible scenario that may not be anticipated well into the future. As is often stated by legislative lawyers, a client could give three drafters the same drafting assignment, and there could be three separate and distinct approaches, all of which could work to address the client's stated goal. As a result, whether it's a practicing attorney trying to advise her client or an enforcement agency trying to apply or implement the statutory language, or the judiciary trying to interpret the law, there may be a dispute in one or more of those instances. And as a result, I think even textualists have to consider legislative history on occasion in order to determine a case's outcome. Besides, since we're trying to ascertain the legislative intent, after all, the lawmaking authority is granted to them, what better way is there to try and glean that intent? Now, in California, I'm the first to admit that our legislative history is quite limited. That is not a criticism of legislative staff, and certainly not our bill drafters at the Office of Legislative Counsel. Instead, I think it's simply a product of our state legislature having to consider too many bills. And with too many bills comes insufficient time that's spent on reviewing bill language and debating its merits or demerits. Instead, for example, the legislature could conduct mock-up sessions similar to those held by the U.S. Congress in the House and the Senate, where legislators actually go through a bill line by line and explain the purpose and intent, transcribe those discussions, and make those available to implementing agencies and judges. While I've suggested that judges in this state should have a better understanding of the legislative process, I also frankly believe that the legislature could do a better job of providing clear language and expressions of intent and better understanding the role of the judiciary in interpreting statutes.